it is a minefield because you could be in one city and the law would be one thing. You could be in another city, the law could be another thing. And that imposes a tremendous burden on the Second Amendment.
Oh, gosh, yes.
We are the Armed Attorneys. Today we're talking about a permit scheme or permit requirement that was struck down. This is a big win. It's out of the state of Pennsylvania. We're going to be talking about what provisions of the Pennsylvania law were found unconstitutional, what things were upheld, and why this is important for everybody, because I think this is instructive on what we can see around the United States. But before we begin, show your support for the Second Amendment by hitting that like button. And so this case is actually very fascinating, brought by the Firearms Policy Coalition. And what's going on?
It is. And I'll say before we get started, I am sick again, so I'm sorry that I'm a little raspy. It's, anybody who has kids, we took my son to one of those like
Petri dishes.
Yeah, he went to his first indoor play place last weekend.
Mistakes were made.
Oh my God, everything he could find, he was like, I don't, how does it feel on my teeth? And I was like, oh, buddy. And so here we are, everybody's sick, but hopefully we get through it okay and it doesn't bother y'all too much. So yes, we have this challenge by the Firearms Policy Coalition in Pennsylvania to several parts of the Pennsylvania Uniform Firearms Act. So in addition to Firearms Policy Coalition, there are some individual plaintiffs. And interestingly, all individual plaintiffs who had at one time been convicted of felony offenses who have since had their civil rights restored. And so we've challenged several parts of this law, including the ability for those individuals specifically to obtain licenses in the state of Pennsylvania, the requirement that you get a license in order to concealed carry or open carry in your vehicle, and we also have a challenge to the carry in Philadelphia law. You can't carry specifically without a license, either openly or concealed.
I hate it when states don't have preemption.
Yes, me too. It's awful. And I think finally, the final challenge here, there were many, many challenges and it all went different ways for us. We've got a challenge to this Pennsylvania law that when there is a declared state of emergency, they can suspend some of your gun rights. And so we have a declared state of emergency back in 2018. It has expired now, but it expired after the filing of this lawsuit. Basically, starting with the opioid epidemic and then continuing through COVID-19. That's all such an emergency. You can't have gun rights.
That always grinds my gears because we see a lot of suspension of, we don't get our rights from the government, but we see the government infringing on rights whenever we have these declared emergencies. Well, guess what? During the founding of the country, we were in a state of emergency, and I think our founders contemplated, like, hey, you don't just lose this stuff because some bureaucrat signed a document. And so it really makes me mad when we see the abridgment of rights because of an emergency.
Sure. What, you think the Revolutionary War wasn't just like super chill?
They're like, oh yeah, all right, this is all good until an emergency happens and it goes all out the window, right? Yep. All right, let's sign off on that.
Sure enough.
Not a thing.
No,
but
not a thing.
All right, so we have the substance of the complaint. This is drafted by the folks at Firearms Policy Coalition. They did a fantastic job.
They've done such good work recently.
But so I would say the two big provisions that we're looking at for our purposes, there's kind of 5 different attacks they had. The two big ones were carrying in the vehicle, open carry in the vehicle, and then this carrying during the declared emergency. And so we see the court briefing on this. We look at, hey, are these facially unconstitutional under the Second Amendment, New York State Rifle and Pistol Association v. Bruin? And we see, hey, guess what? The court upholds these are facially unconstitutional. They grant summary judgment in favor of Firearms Policy Coalition, these plaintiffs, with respect to those two particular provisions. Now, the court doesn't give them everything that they want. There were, 5 challenges. They gave them 2. They held back 3. And yeah, the city of Philadelphia is one that they did not address.
Right. I mean, essentially, it's not pled in the right location and it's not pled properly. So they've got time to refile to get that done. Essentially, I mean, you have to present the controversy correctly to the court system. So what they're going to have to do is come back and say, we intend to carry in Philadelphia. There is an imminent harm, right? We have standing, we're pleading, imminent harm, and we're filing it in the Eastern District. We're filing it in the locale in which there is an issue. So that all makes sense to me.
Yeah.
And the 2 winners we have really is they are highly consistent with other opinions that we've gotten recently, telling people you can't have a firearm in your car without getting licensed is highly restrictive on the Second Amendment.
Extremely. And, we threw up the case earlier, but for those listening along, this is Suarez v. Ivanchik. This is 21 CV 00710. If you wanted to go follow along and check out the kind of filings in that case and follow along the opinion if you wanted to research it further. But this statutory preemption, I got to go back to that for a moment.
Oh, yeah.
Yeah, because, what we see in gun hostile states, and this is something that, I think Second Amendment advocates need to be aware of. This is an issue that needs to be on your radar. If it's not on your radar, is the issue of statutory preemption. And that's when, if we have statutory preemption, that's when the state legislature takes the authority away from municipalities, cities, or counties. They say, hey, we're going to regulate everything on the state level. And what that ensures is that state laws are uniform throughout the state. So that way, I know if I'm in the state of Pennsylvania, it doesn't matter what city I'm in, I know the law at the time, wherever I am. And these states that do not have statutory preemption, it is a minefield because you could be in one city and the law would be one thing. You could be in another city, the law could be another thing. And that imposes a tremendous burden on the Second Amendment.
Oh gosh, yes. So we've got our two issues here where we won, guns won, right? Open carry in vehicles without a license and being able to not have your rights restricted during these constant states of disaster. We've got our issue, which is, unfortunately, there is no preemption. So we've got our very specific to Philadelphia issue, which is just pushed to the side. Go figure that one out, you guys.
Yep.
And then we've got our two loser issues, right?
Yeah, that they upheld the requirement that you need a license to carry concealed in the state. Mm-hmm. That was upheld. And then our third issue was if you had previously had suffered a disability that would prevent you from getting a license to carry, in this state, having been previously convicted of a felony, well, these folks went the extra mile, got their rights restored. They said they upheld that restriction saying, hey, guess what? This restriction is allowed to stand. So we have those three issues. Philadelphia still needed a concealed carry. People who've had their rights restored, we can still prevent them from getting a license.
Right. So, I think the reasoning here, is kind of similar to things that we've seen throughout the country. I don't agree with it, but this is the reasoning, is that basically if you are still giving the avenue to someone, then you're okay. You probably didn't violate Bruin. So you have to have a license to conceal carry, but you can still open carry without a license. And it's a shall issue permitting scheme. So court concludes we're all okay there, not violative of Bruin. And this issue of can you deny people who have had these previous convictions? Well, it's still a shall issue scheme, right? Not a may issue scheme. And essentially they're saying, sure, they've got gun rights in other places. It's just the denial of a license. States are still fully allowed to put their own hoops in place to jump through and make you jump through those hoops in order to qualify for that license. Again, not saying we agree with that, but it is consistent with rulings that we are seeing post Bruin throughout the country. It's not particularly surprising.
No, and another kind of case just to illustrate the point, we see this with the Made in Texas suppressor challenge. We've seen the courts say, hey, guess what? You're not prohibited from getting a suppressor. You just have to jump through the hoops of the National Firearms Act, pay the tax, submit your application, get approved. And so there's an avenue here. So we're falling into this kind of intermediate land where, all right, when some conduct is prohibited, you can't possess a firearm, or you can't carry a firearm, or you can't have this type of firearm. Well, those are really clear restrictions that are black and white. When you have these kind of intermediate, well, there's a way around it. You just got to, jump through the hoops. I call hoops infringements.
Yeah, it is. It's a little bit disheartening because, take yourself back to May of 2022 or June, May, and we all read the Bruin decision and we were like, there are no more gun laws, right? Which was, it was an exciting time to be alive. And, we see that the courts are applying Bruin in such a way, in a more moderate way, I think, than initially we were all hoping for.
Yeah, more than I was hoping.
So, what does this mean for all of us going forward? I think that this case, if you really dig into it, and hopefully you were, I know it's a lot of legal issues here that we talked about, but this is highly instructive for what is going to happen in challenges all across the country. I think that courts are going to look and say, is it a total restriction? because there's not a lot of text history and tradition for that. But if we have these sort of, you still have an avenue, there's some partial restrictions, they're going to find a Bruin justification for it.
And it's a damn shame.
It is a damn shame, but here we are.
But we hope you enjoy this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please comment for us below. Do you think that Bruin is being faithfully applied? Do you agree with what the courts are doing? Until next time, we're the Armed Attorneys.